let us begin. Welcome again. Thank you for joining this webinar and today's topic, international family law. Many people, when they are in a relationship, they are both living in South Africa or they're living in the same country. That is most of the time the case. They have a child together, they get married, whatever the case is, but they are connected to South Africa or to a Pacific country. Things change, things happen, the parties separate. One party decides to move overseas for work purposes, the other party decides to remain in South Africa. The child gets born, the child decides to, or the parent decides to move out of the country into a different country, or the other parent who is supposed to pay child support moves to a different country, or the parties are living in different countries, one in South Africa and one in a different country, but they have a child together and they are struggling to exercise their parental rights and responsibilities regarding the child, care and contact, and so on. Therefore, today's topic, international family law, dealing with a family law scenario where one party lives in South Africa and the other party lives overseas. So that's the theme of today. If you have any questions on this specific topic, feel free to pose it on Facebook Live on the Advocate Muhammad Abduroaf Facebook page. You are also welcome to call in to this webinar via our Zoom line. You're welcome to do that. And you can interact with me orally or verbally, whereby I can hear what you are saying and you can hear what I'm saying, and you can unpack the specific legal problem that you may have. So that's something new. Go to the web page www.abduroaf.co.za/Zoom, and that should take you to some page or some form whereby you can register for the specific webinar. So I'm just activating that now. Wonderful. And we are there. So if you are partaking, if you want to partake in this webinar via Zoom, your camera will not appear. The screen before you will remain the same. All that will be there would be your voice, and we will be interacting via Zoom. I might be able to see you. You can maybe see me via the Zoom video, but the audience, the public, won't be able to see. So that is great. Something new, something we're working on, and something we hope that you will try to use and implement. And we're ready to deal with that. So if you have a question, feel free to use the Zoom link or the Facebook Live link. Let us get back to the topic at hand, international family law. I do see a question that has come in, and I think I just want to copy and paste that specific question into the whiteboard. So when I discuss these topics, I do not have to repeat myself. Let's get to the whiteboard. Question number 4, or maybe it is, will be the live question. Okay, the live question is, how does a person residing in South Africa adopt a child who is residing overseas? Something interesting, and it does fall under international family law. Let us begin with the first question. Question number 1. How do I obtain maintenance if the other parent is overseas? It is important to note that when the other parent is overseas, the local courts no longer have jurisdiction over that specific parent. That's important to note and understand. South African courts have no power and no authority over another country. It doesn't make sense. It's almost like saying the American court, that side, the magistrate's court there, can have authority over our citizens or our residents here in Cape Town or in Johannesburg. It doesn't work that way. Each country is autonomous, they're all sovereign, and no court can order someone in a different province, someone in a different country, to do something or not to do something. That's not how it works, and each country has its own laws, and you have to respect those specific laws. However, many times countries enter into agreements with other countries where they have certain type of understandings in place because they know there are certain problems that are that could arise in both the countries. And one typical example would be the extradition laws, where a fugitive might commit a crime in one country and go to a different country. Obviously, the country who is looking for the specific fugitive, they cannot just go into the other country where the fugitive is and wave some badges and say we're here to take this person out of this country. No, it doesn't work that way. They require to have consent from the respective countries, and generally this is done by an agreement. So that's where the extradition laws comes in, whereby one country would approach another country and say, in short, there's someone we're looking for in your country. He is wanted in our country for the specific crime. Please assist us in extraditing him. Obviously, then court procedures will take place, and then ultimately, if the person is a fugitive in South Africa, South African courts will now decide whether or not to have him extradited or not. So that's something to assist us in understanding where I'm going to. When it comes to child maintenance laws, the same principle basically applies, the same flavor. If you have a maintenance order in South Africa that says the other party has to pay X amount of maintenance, you cannot send that order down to the other country and show it to their maintenance court or their court and say, I have a court order from South Africa. I'm here to attach his salary. I'm here to sell his house, to sell his car, to get a garnishing order, etc. They will say, what is this document? We see a court order. It's not one of our courts. Why should we do anything about it? It's a foreign order. We do not even know whether or not it is legitimate, etc. Then we have to look at international law. This is a problem because, let's say in our scenario, it's between South Africa and the United Kingdom. South Africans living in the United Kingdom have the same problem as people who are from the United Kingdom living in South Africa when it comes to child maintenance. That is where countries come together and create certain laws or agreements, international agreements and instruments that can be applied and assist countries in resolving these type of issues. Now, South Africa entered into an agreement, international agreement, with various countries who are part of the REMO Act, the Reciprocal Enforcement of Maintenance Orders Act. Now, in terms of the specific act, if you live in South Africa and the other parent is in a signatory country, for example, United Kingdom, United States, depending upon the state in the United States, there's an agreement in place, basically stipulating that if there is a maintenance order made in South Africa and the party who has to pay the child maintenance lives in, for example, the United Kingdom, in our scenario, if diplomatic channels are followed and that specific order is registered in my country, in the specific case, the United Kingdom, and diplomatic channels has been followed, it followed the specific, went via the government, it has been endorsed, it has been checked, etc. And an inquiry takes place in my country, let's say, for example, the United Kingdom, and they are satisfied that the person living in the United Kingdom is the parent of the child living in South Africa. He can afford to pay the child maintenance. They looked at the amount requested, etc., the age of the child, they verify that he's a father, and so on. And the United Kingdom will now make an order that he is obliged to pay the child maintenance as per the order made in South Africa. That's the long and the short of it. And the reciprocal applies as well. If someone lives in the United Kingdom and the other parent lives in South Africa and the child lives in the United Kingdom, of course, that person will follow the same route. Approach the local court in the United Kingdom, I do not know how they work there, and say there's a child involved here, maintenance is what I require, so much money. The United Kingdom court will inquire into the matter and come to some type of an amount. They will say, this is the amount we think our client is entitled to. They'll send that documentation via diplomatic channels, via the government, to the local court in South Africa where the party who is supposed to pay child maintenance resides. They will take the documentation, they will call the other party in via by the procedures laid down in the Maintenance Act, subpoena him to the Maintenance Court. He or she will come. He or she will be presented with an order that was made in the United Kingdom. They'll do a full-blown inquiry with a specific parent. Firstly, confirm, are you the parent? Are you disputing it? Whatever the case may be. What are your earnings? How much can you afford to pay? You can dispute the amount requested. You can say it's too much, etc. And at the end of the day, it's the local court in South Africa who will come to a conclusion on what a reasonable amount of maintenance is, and it will be made an order of court. So there's an order, two orders, all dealing with the same parties, one in the United Kingdom and one in South Africa. Therefore, if the party living in South Africa does not adhere to the maintenance order, he or she is committing a criminal offence. But long and short of it, it's possible in terms of the Reciprocal Enforcement of Maintenance Orders Act for a parent living in one country to apply for maintenance or obtain a maintenance order enforced in a different country. That is a question which I've posed to myself and for your benefit. No one specifically requested it, but all that I'm here to bring to your attention is it is possible to claim maintenance from a parent living in a different country. It's a bit long, it's a bit of a tedious process, depends on a lot of factors, how long the postage takes, how long the documentation takes to get to the other country, how long the other country takes to do the inquiry, to get hold of the other party, etc. But it needs to be done and it can be done. Let us move to the next question. But before I do that, I want to check if there are any additional questions on my... Yes, there's another additional question on our Facebook Live page. Let me copy that in so I can be on top of things. Will be question number 5. Let me have a quick look at the Zoom. Sometimes people partake in the Zoom, but they do not want to, they join the Zoom, but they do not want to ask a question. I would like to verify those things. Okay, the Zoom line is looking fine. If you have a specific question, please register with the Zoom line and I'll try my best to answer it. Let us deal with the second question. How do I get, now this typo there, the notepad doesn't do spell checks. How do I get divorced if the other parent is overseas? Very interesting question and something which I deal with on a regular basis. Comes to the table a lot, whereby one parent lives in South Africa and the other parent lives overseas. And generally, it's the parent living in South Africa that wants to divorce the other parent. But many times it does happen where the parent living overseas wants to get divorced from the parent living in South Africa. And 9 out of 10 times, these divorces are done by agreement. The parties are, amicable or amiable to the divorce. So, to fast track where I'm going to with a specific scenario, even if you were born in South Africa, your child was born in South Africa as well, you got married in South Africa, you lived in South Africa, but now you are living overseas. And that has become your home. You move to the States, from the States you move to the United Kingdom, from the United Kingdom you move to Japan. You no longer consider South Africa as your permanent home. You are paying taxes overseas. Then under those circumstances, South Africa cannot get divorced. Cannot divorce you because you are no longer domiciled, you're no longer resident in South Africa. We have no jurisdiction to deal with your specific divorce. Now, I will not go into the technicalities of it, but the long and short of it is, in order for South Africa, a South African court, specific South African court, to divorce you, you need to basically be domiciled within its area of jurisdiction. You need to be living here. You can be working overseas, that's possible. But South Africa must be your home, and a specific province or a specific location needs to be your permanent home. Therefore, if you move overseas and you used to live in Cape Town was a permanent home, you cannot get divorced in Johannesburg court, because Johannesburg court never had jurisdiction over you. Although you lived in South Africa and Johannesburg is within South Africa, you still need to approach the Cape Town court. One of the parties needs to be living in Cape Town in order for Cape Town to divorce you. But if you moved out of the country and you consider a different country as a permanent home, you cannot come with an argument and say, but I lived in South Africa, South Africa used to be my permanent home, etc. If one of the parties are living in South Africa, we make the scenario very easy. He or she is living in Johannesburg, and the other party lives in, let's say, the United Kingdom. Our sheriff, our local sheriffs that usually serves divorce summonses on the other party would usually be South African, and he will have his specific jurisdiction to serve documents on. So the Cape Town sheriff will deal with Cape Town, the Johannesburg sheriff will deal with Johannesburg area, and the various smaller suburbs within that specific area. But here the party lives overseas, and our sheriff has no power. He cannot go fly all the way down overseas. That won't work. It won't make sense. So under those specific circumstances, there's something called edictal citation, whereby you can serve these specific documentation on the other party, possibly via email, via Facebook. That also happens now and again, or a local attorney that side, or the sheriff that side. But basically, you'll have to ask the court permission and advise the court, I've issued summons, the other party lives overseas. Please give me consent that I can serve this specific documentation on the other party by email or via the local sheriff that side. So it gets couriered down to the other side. The sheriff that side will serve it on the other party, or the serve it upon an attorney. So you post it to an attorney that side, or solicitor, or barrister if they do it, and it will be served on the relevant party by that person. That specific serving party will send some type of documentation down to our local courts, to South African courts, and stipulate, I have delivered this specific documentation to the other party, explain to him, etc., what it entails, etc., and he would be served. Not in the ordinary fashion, as he or she would have been served locally in South Africa by the office of the sheriff. So it is possible for that to happen. If the parties are in agreement regarding the divorce, so both the husband and the wife wants the divorce, but the husband lives locally in South Africa and the wife lives overseas, the simplest way to avoid that would be to have the plaintiff be the one living overseas and the defendant being the one living locally. Because then in the divorce summons documentation, the attorney will be representing the foreigner for the divorce, but the documents will have to be served on the local person here, and the sheriff can easily serve it upon him or her. That will sort out that specific problem, and there's no need to apply for edictal citation, etc. So I think that specifically deals with that specific scenario, and all that I'm trying to bring to your attention is that it is possible to divorce someone even if the other person lives overseas. So as long as the local court has jurisdiction to attend to the divorce, meaning one of the parties has to be living here in South Africa or have been living here, but still considers South Africa as his or her home. And many times people go overseas for work purposes. If someone left to overseas just before the lockdown and is struggling to come back to South Africa because of traveling restrictions, South Africa is still his or her home. And even if he or she is overseas and the other party is still in a different country, so both parties are not in South Africa, the divorce proceedings can still commence. The only difficulty is someone has to appear in court to give evidence as to, the marriage having broken down, the minor kids, and so on. That can be complicated, possibly with COVID-19 and the court implementing video conferencing, video court proceedings, etc. You might find a judge who's willing to attend to the divorce on that basis. But that's something novel and something you can consider and discuss with your attorney or advocate and take it from there. The third question before dealing with the live questions would be, how do I apply for custody if the other parent is overseas? Something which we deal with on a regular basis, and considering the fact that many people do not continue living with each other after they have separated. One party will decide to go overseas for better life for him or her. The same principle will generally apply in the sense of the documentation would have to be served on other party via the sheriff if he or she was locally, but he or she is not living locally. And the principle of edictal citation would apply again, whereby you ask the court consent, can I serve the specific documentation on other party via email, via a local attorney that side, a solicitor, whatever the case may be, or from messaging agency, etc., depending upon what's available in the country. Each country is different, all circumstances are different. Facebook is a possible way of serving on other party. The person is using the account regularly, updating status is always there. And WhatsApp, that could possibly work. Fax, I do not know who faxes. I never received a fax for a very long time, and if I do receive a fax, it's all done by digital lines. But be that as it may, it is also possible. So the challenge you will have is if you serve this documentation on the other party, wonderful. That specific party will have to come, not necessarily have to come down to South Africa, but will have to now deal with the South African courts, and the family advocate's office would want to consult with a specific party if he or she, if the matter, requires that. But that's something on the side. The family advocate can always have a Zoom meeting of a WhatsApp video, FaceTime, etc. Microsoft Teams as well. So that's something that you can, try to circumvent. But the bottom line is, even if one party lives in a different country, as long as the local court has jurisdiction to hear the matter, wonderful. We can deal with that matter. It's not a problem at all. Now let us deal with the live questions that came by the Facebook Live platform. Let's get a bit further up. If you want to interact with me via Zoom, the link is above there, www.abduroaf.co.za/Zoom. Feel free to register if you watch this video later on. When I do go live again, you would have the link and you would be able to partake with me immediately. The first live question is as follows. How does a person residing in South Africa adopt a child who is residing overseas? It is possible. That isn't an issue. The Children's Act, I would actually advise this person, the procedure is quite arduous, it's quite long. So I would actually advise you to have a look at the Children's Act, Google it, the Children's Act, and have a look at a section dealing with international adoptions. Obviously now we're dealing with two countries, where one party, the parents might be living in South Africa, but the child is now living overseas. And it's not like a local adoption whereby you get a local adoption social worker involved, you get the children's court involved locally, etc. Here we're dealing with something concerning international adoption. So I would actually advise you just to have a look at the Children's Act. It deals quite explicitly regarding the procedures that will have to be followed for international child adoptions. All that I can add to this point, I have dealt with this in the past. It is possible to be done. And have a look at the Children's Act. I think that will assist you greatly where that is concerned. The last question, unless more questions come, up there. If I should immigrate, can I request my child to come visit me during school holidays, and from what age? So I would presume immigrate, go to a different country. Yes, you can request. You're always welcome to do that. And hopefully the other party will agree to that. Remember, if the minor child wants to leave the Republic of South Africa to visit you wherever you are, both parents' consent would be required for that specific purposes. And for the child to return to South Africa, and at the same time for the child to apply for a passport. Very important. So if you do decide to immigrate overseas, make sure the child has a valid passport, number one, and the other party agrees to that. If the other party is not willing to agree to that, it's best to get a court order in place before you go overseas, whereby the court order will specifically stipulate that the other party should agree. If he does not want to agree, then that specific requirement does not need to be fulfilled after being requested, giving him 7 days notice to provide the necessary consent. Regarding the age, I think it depends all upon you and the maturity of the child and the safety of the child traveling overseas. You say the child is school-going age, if there can be a chaperone with a minor child, to wherever we are going to. It depends on the country, the circumstances, how many flights the child should take, etc. If it's workable or not. If the child has to take 3 or 4 connecting flights